Hi, so today we're going to go through a purchase and sale agreement because that's if you found the home, once you found the home, you know what you want. You want to make an offer on this home. So let's go through this because this is highly important for you to understand the document and the contract that you will be entering into. I know a lot of times people are like, what are next steps? And I might just speak through it really quick, but I thought it would be nice to have like a seminar that you can go back to and kind of look at and walk through the purchase and sale agreement. So I'm going to share that with you now. And then I'll come back to the timeline. Okay, so purchase and sale. And for and in consideration, so a lot of legal words, mutual covenants herein, and other good and valuable consideration, the receipt and sufficiency of which is hereby acknowledged, the undersigned buyer. This is where your name will go if there's two of you. Undersigned seller, their name is here. The tract of land, we have an address. I just have Oak Ridge in here. It could be anywhere in Tennessee, but the city. Recorded in, this would be the county. If it's in Oak Ridge, it's Anderson or Roane. Instrument numbers. So we make sure that it's the specific property that we're speaking of. So when things are sent to the title company, everything that you want included as part of the property. So anything that's attached, the light fixtures, if there's something attached to the windows, those are all wall-to-wall carpet. Those are all considered part of the house. But other properties that remain, and a lot of times it might be like, the oven, self-cleaning oven, disposal, even though that's in the sink, we always list it, maybe the microwave, any other thing in the house that you're asking for. Usually they have it listed out on the property explanation. You've got the sheet that says this is the address, this is what's included. Maybe you want the outdoor kitchen. So anything that you're asking for them to leave will be listed in here. Items that shall not remain on the property, old paint, in closet, maybe you want them to get rid of it because you don't want to have to get rid of it. You want to specifically speak to that. You don't like the shed in the back, shed in backyard, or maybe you want to keep the shed, whatever it is that you want or don't want, we're going to put in here. Okay. Buyer does not wish to assume, it's very unusual for them, leased items that remain with the property. Like say there's a leased security system, just like it says here, a fuel tank. If you want them to leave it, then we'll put it in here. If you don't, we'll check this, tell them, get rid of it all. If you're keeping, say you're keeping the fuel tank because it's a propane tank, then the fuel will be adjusted and charged to the buyer and credited to the seller at closing. The title company usually handles that. It's pretty easy. Okay, the purchase price. So here's where we put how much you're willing to pay for it, what you're negotiating, what you're asking them to accept. Okay. Financial contingency. So this is really important. A lot of times, so I will be asking you beforehand, what kind of loan are you getting? How much are you putting down? Are we asking, are you going to be doing like a VA loan? A lot of times is 100% loan. I think there may be some FHA loans out there that are 100% USDA. I'm not a loan officer, so don't say, well, Pam said this, because this is why I always say, let me talk to your loan officer. I need a pre-approval. I need to know exactly what's going on, because then we can put in here whether it's a 95%, 100%, 97. If you're just putting 3% down, what kind of purchase price you're doing? Is it an 80%? Or if it's all cash, I'll leave that out. we need to know what kind of loan it is because everybody wants to know what we've got going, VA, conventional. And if it's a VA, we're going to attach an addendum. Okay. I froze for a minute there. I want to make sure that we're still running. Okay, so what we need to, again, I'm going to state it out again, just in case I froze. What type of loan? And that's really important. And this will help in the negotiations. Okay. So loan obligation. The buyer agrees and or certifies as follows. So within 3 days after the binding agreement date, once we come to an agreement, they accept your terms, they like it. The buyer shall make application for the loan and shall pay for the credit report. This is really important because at 3 days, and you're going to be held to this. And then we notify the seller or the representative that you've applied for the loan, and that the agent will, you say, I've done that. And we make sure that it has been relayed to the seller. Within 14 days after the binding agreement date, again, we fill out this purchase and sale agreement. We send it to the seller. They accept it, sign it, send it back. The date that they do that, that would be our binding date. And or they send us back a counter. Now we're still negotiating, so we don't have a binding date. None of this has started. But from the date that we have both signatures and everybody has gone, yay, verily, we have an agreement, that would be the binding date. The following day is day 1. So within 14 days after the binding agreement, that's when you have to have, now everything starts. So you're going to get a hold of an insurance company. You're going to find out about hazard insurance and intent to proceed. You have available funds to close per the signed loan estimate. So you're going to also get a loan estimate from your mortgage company. Buyer shall pursue qualification for and approve of the loan diligently and in good faith. Buyer shall continually and immediately provide requested documentation to lender. Unless otherwise stated in this agreement, buyer represents that the loan is not contingent upon the lease or sale of any other property. So if you've got to sell something else, we would have already stated in here and say it's contingent. So this right here, unless stated otherwise in the agreement, and I would state that if you told me, Pam, we need to sell our house, or then we would have what they call a contingent offer. And buyer shall not intentionally make any material changes in their financial condition, which would adversely affect buyer's ability to obtain the primary loan. That means don't run out and buy a car, intentionally changing something so now you don't qualify, because then that's going to affect your earnest money, which we will discuss down in further in this document. Okay, so if we check this, the financing contingency waived, that's if you have cash. So if you're a cash buyer, it changes it. Appraisal. This agreement is not contingent. We don't want to check that unless for some reason, I know during COVID and just after that, when everything was crazy, people were buying without being, they were paying extra and not being concerned about the appraisal. This is not something I suggest. So if you're buying cash, then there's no appraisal. You're not paying for an appraisal. So that would be checked if it was cash. Is contingent upon the appraisal value, either equaling or exceeding the agreed upon purchase price. And the buyer pays for the appraisal because this is your appraisal and it's your person coming in. So let's read this. If the appraised value is equal to or exceeds the purchase price, this contingency is satisfied. In consideration of buyer having conducted an appraisal, the sufficiency of such consideration being hereby acknowledged. If the appraised value of the property does not equal or exceed the purchase price, buyer shall promptly notify the seller via notification form or equivalent written notice. It's easier to use the notification. It's already set up. Buyer shall then have 3 days to either waive the appraisal contingency. If you have a loan, they're not going to do that. Terminate the agreement by giving notice to seller that you're going to terminate. Or a lot of times we can negotiate with the seller. What I always do, I've had this happen, we negotiate with the seller to take the appraised value. If they won't, then we terminate the agreement. At that point, buyer's entitled to a refund of their earnest money. In the event buyer fails to either waive the appraisal contingency or terminate the agreement as set forth above, the contingency shall be deemed satisfied. So this is really important. Once we get that appraisal, then we kind of move and see what else, if we need to renegotiate or walk away. Okay. Seller expenses. Seller shall pay all existing loans and or liens affecting the property, including penalties, release preparation costs, applicable recording costs, any accrued or outstanding association dues or fees. This is so that you don't end up with their debt. Okay. Buyer's expenses. Oof. Buyer shall pay all transfer taxes and recording fees on deed and conveyance and deed of trust. Buyer's closing fee, document preparation fee, and or attorney fees, preparation of note, deed of trust, or other loan documents. When you talk to your loan officer, he or she is going to give you a document. I can run a little document that would have, okay, fees computed here, estimates, anyway, we go to the title. The title company can give you a few of these things, kind of give you a rundown of detailed closing costs, maybe that you're always going to need. This is, don't get nervous because this, I just ran something here. It was a $300,000 house. 14 months of insurance is what you're going to have to bring to close, 4 months of taxes, 30 days of interest. So there are expenses, and that's why a lot of times when people come to me and they say, I can get 100% loan, I don't need any money, but you do. There's always expenses that are going to have to be paid by you. So what I like to put in here, title expenses, because it's more of a balanced market right now, usually what I say, all parties to pay their own expenses. Now, if it's a new home tract, a lot of times that seller to pay $6,000 to $8,000, sometimes $6,000 towards buyer's closing costs. Sometimes we can get that. And I add extra things in here, you know, seller to pay buyers buyer's real estate commission of whatever percentage, so that you're not responsible for that. Seller to leave refrigerator, you know, whatever we're asking for, this is an area that we can put this in. Okay, closing agency for buyer. So a lot of times, there are times when the seller will have a specific person that they want to close with. Maybe you have a relationship with a title company that you want to use. I like to get these to match because it makes for an easier closing. And if we're negotiating, say it's a very popular house and we're kind of competing with other people, I may call up the agent and go, hey, where do you like to close? And that makes it's a little more comfortable. Or if they recently bought the house, they haven't had it that long, and especially if it's a new builder, they have a agency they like to work with who can make title quicker and possibly less expensive. Okay. Earnest money and trust money. So buyer shall pay within, and you pick the days, usually try within, so 5 days, 7 days, especially if we've got a weekend coming up, so that you can deposit the earnest money with the holder. I will not hold money. I like to put it at the closing agency because it just makes the most sense. They've got a trust fund that they can put it in, an amount of money so that they can hold it and it's available for closing. Okay, so failure to receive the earnest money in the event the earnest money is not received within the amount of days. So if you don't get the earnest money turned in, this agreement can become null and void. So you have buyer shall then have, so if you do not turn in the money, you can't get it over there. Sometimes there's a problem, like, your bank is out of town and you're kind of having a little bit of trouble. We can work through that. But if not, then the seller is going to send you, they're going to send me a form. I'm going to forward it to you. And that means that you immediately have to get that in, or this whole thing falls apart. Okay, so handling of earnest money, I should probably just read this. Failure to receive it in the event earnest trust money is not timely received by holder, or earnest money, trust money, check, or other instrument is not honored for any reason by the bank upon which it is drawn, holder shall promptly notify buyer and seller of the buyer's failure to deposit the agreed upon earnest trust money. Buyer shall then have 1 day to deliver earnest money in immediate available funds to the holder. In the event buyer does not deliver such funds, buyer is in default and seller shall have the right to terminate this agreement by delivering to buyer or buyer's representative written notice via the notification form or equivalent written notice. In the event buyer delivers the earnest trust money and immediate available funds to holder before seller elects to terminate, seller shall be deemed to have waived seller's right to terminate, and the agreement shall remain in full force. So handling of the earnest money, this is important. This is your money. Earnest money is to be deposited promptly after the binding agreement date or the agreed upon delivery date in the earnest money, trust money section, or as specified in the special stipulation section. Holder shall disperse earnest money as follows: at closing to be applied as a credit toward buyer's purchase price, upon written agreement signed by all parties having interest in the funds, upon order of a court or arbitrator having jurisdiction over any dispute involving the earnest money, upon a reasonable interpretation of the agreement, or upon the filing of an interpleader action with payment to be made to the clerk of the court having jurisdiction over the matter. Holder shall be reimbursed for and may deduct from any funds interpleaded its costs and expenses, including reasonable attorney fees. So this is if we go to court, the prevailing party in the interpleader action shall be entitled to collect from other party the costs and expenses reimbursed to holder. No party shall seek damages from the holder, nor shall holder be liable for the same for any matters, a lot of legalese, arising out of or related to performance of holder's duties. So basically, this earnest money, this is a contract. This is highly important. We want to approach this solemnly and be prepared. You're putting money down. Now, you would be if if we back out of, for any reason, if we have a notification, I think I stated it up there earlier, you get your earnest money back if something happens, not your fault, and we're backing out, you will get your earnest money back. And there's some more places in here that'll discuss that. So closing, we pick a closing date of when we're going to close. We need to be able to kind of have a concept of when we're going to close. I usually talk to your loan officer, might take 30 days or 45 days. They usually give me an estimate. Okay, so possession of the property, we would like it at closing, unless they're going to do a temporary occupancy agreement, which is unusual to do before closing. And that would be something we could agree on that later, but I like to say at closing. Prorations, real estate taxes, rents, maintenance fees, and associated fees on said property for the calendar year in which the sale is closed shall be prorated as of the closing date. So it means you're not going to be paying taxes for previous years. So in the final tax rate for the current year has not been set by the taxing authority at the time, they prorate it. So, the seller will owe a certain amount and you will prepay the rest. Okay. The parties agree to pay their okay, let's go back. If the final tax rate for the current year has not been set by the taxing authority at time of closing, the tax rate and property assessment for the immediate preceding calendar year shall be utilized for calculation of the tax proration. In the event of a change of reassessment of taxes for the calendar year after closing, the parties agree to pay their recalculated share. Real estate taxes, rents, due, maintenance fees, and association fees for prior years and rollback taxes, if any, shall be paid by seller. These are all things that are taken care of in the title. And at closing, if it's confusing, I always have the title or the attorney sit down and explain it so you can see it. Greenbelt, it's only if it's a minimum of 15 acres or otherwise qualifies if you're going to keep it as a greenbelt, and that's a tax savings. And those are special stipulations that we would have to talk to you about. If buyer does not intend to maintain the greenbelt status, again, this is only for more than minimum of 15 acres, so 15 acres or more. Special assessments approved or levied prior to the closing date shall be paid by the seller at or prior to closing unless otherwise agreed as follows. That's very unusual. It's usually kind of left blank, so. Warranties, seller at the option of buyers or buyer's cost agrees to transfer seller's interest in any manufacturer's warranties, service contracts, termite bond, or treatment. So like if they have a termite contract, if you want them to transfer it to you, you can do that. Association fees. Buyer shall be responsible for all homeowner or condominium association transfer fees related administration fees, not including statement of accounts, capital expenditures. So the association fees you're taking over. Title and conveyance. Seller warrants that at the time of closing, seller shall convey or cause to be conveyed to buyer or buyers assigns good and marketable title to said property by general warranty deed subject only to zoning, setback requirements and general utility, sewer and drainage easements of records on the binding agreement, date upon which the improvements do not encroach, subdivision and or condominium declarations, covenants, restrictions, and easements of record on the binding agreement date, and leases and other encumbrances specified in this agreement. If title information, closing or loan survey pursuant to Tennessee Code Annex 62-18-126 boundary line survey or other information discloses material defects, buyer may, at buyer's discretion, accept the property with the defects or require seller to remedy such defects prior to the closing date. Buyer shall provide seller with written notice of such defects via the notification form or equivalent written notice. If defects are not remedied prior to closing date, buyer and seller may elect to extend the closing date by mutual written agreement, evidenced by the closing date possession amendment form or other written equivalent. If defects are not remedied by the closing date or any mutually agreed upon extension thereof, this agreement shall terminate and buyer shall be entitled to refund of earnest trust money. So this, if the title company does an examination and they find any problems, we work through it, back out if they can't fix it. This way, you're not stuck with something with defects, property issues. Good and marketable title as used herein shall mean title, which a title insurance company licensed to do business in Tennessee shall insure at its regular rates, subject only to standard exceptions. The title search or abstract used for the purpose of evidencing good and marketable title must be acceptable to the title insurance agent and issuing title insurance company. Seller agrees to execute such appropriate affidavits and instruments as may be required by the issuing title insurance company. Buyer warrants buyer has reviewed Tennessee Code Annex Title 66, Chapter 3, Part 3, and is not prohibited foreign party or prohibited foreign party controlled business, prohibited from purchasing agriculture or non-agricultural land. So this has to do with foreign party. So if you're not a United States citizen, then well, this needs to be discussed. Deed, name on the deed to be. So this is where you stated out whose name it's going to be in. Association lien payoff in the event the property is subject to mandatory association assessments or other fees which may impose a lien. Seller shall cause to be delivered to buyer or buyer's closing agent. I'm having trouble talking. Not later than 7 days before closing a lien payoff, estoppel letter or a statement of account reflecting the account relating to the property is current or setting forth the sum due to bring to a closing, to the account current at closing. So if there's a lien on the property from the HOA, that's going to be taken care of before you take possession. Public water or public sewer systems, in the event it is discovered that public water or public sewer system is accessible to the property and connection to the property is required by a governmental agency, authority, or lender, buyer shall promptly notify the seller via the notification form or equivalent written notice. Seller and buyer shall have 5 days following such written notice, but not later than closing date, to negotiate in good faith the payment for the cost in connection to the public water or public sewer system. In the event seller and buyer do not reach a mutual written agreement for the payments of such cost or mutually agreeable written extension of such time period as evidence in an amendment to this agreement signed by both parties within such period of time, the agreement is hereby terminated. If terminated, the buyer is entitled to a refund of the earnest money. So there's so many places in here where you're entitled to the earnest money if things are not fulfilled. Lead-based paint disclosure. So that's a separate thing, and we can go over that. If the property is built before 1978, there's going to be a lead-based paint disclosure that you will have to sign and get a little bit educated on that. Okay, this is an extremely important part right here. Inspections. So I always say get an inspection. Buyer's right to make inspections. All inspections reports, included but not limited to the home inspection report, those required, recommended in the home inspection report, Wood destroying, insect infestation, termite, that's a termite report. Septic inspection and well water tests are to be made at buyer's expense. So any inspections you want, you have to pay for unless we've stipulated some kind of agreement. The parties agree that in the event buyer shall elect to contract with a third-party inspector to obtain a home inspection, said inspection shall be conducted by a licensed home inspector. So you can't just have Uncle Joe come in and do the inspection. Nothing in this section shall preclude buyer from conducting any inspection on buyer's own behalf, nor shall it preclude buyer from retaining a qualified and, if required by law, licensed professional to conduct inspections of particular systems or issues within such professional expertise or licensures. I can't speak, including but not limited to inspection of the heating, cooling systems, electrical systems, foundation, so long as said professional is not in violation of Tennessee Code Annex 62-6301. Seller shall cause all utility services and any pool, spa, and similar items to be operational so that the buyer may complete all inspections and tests. Under this agreement, buyer agrees to indemnify seller from the acts of buyer's inspectors, and or representative in exercising buyer's right under this purchase and sale agreement. Buyer's obligations to indemnify seller shall also survive the termination of this agreement. So you want to get someone licensed and that they're not going to screw things up. Buyer waives any objections to matters of purely cosmetic nature, decorative color or finish items disclosed by inspection. Buyer has no right to require repairs or alterations purely to meet current building codes unless required to do so by governmental authorities. So it's an older house and it doesn't meet 2025 criteria, but it did meet it when it was built. We cannot require them to bring it up to a certain standard. That's just not part of, unless you've made that agreement, unless somewhere in here we make that agreement and they sign it. As far as the inspections go, we can't do that. I know that's confusing, so feel free to contact me and we can go into it further. Initial inspections. So this is really important because all the inspections that you're going to make, buyer and or buyer's inspectors representatives shall have the right and responsibility to enter the property during normal business hours for the purpose of making inspections and or tests of the property. Buyer and or buyer's inspectors representatives shall have the right to perform a visual analysis of the condition of the property, any reasonable, accessible installed components, the operation of the property system, including but not limited to the following components: heating, cooling, electrical systems, plumbing systems, structural components, foundations, roof coverings, exterior and interior components, any other site aspects that affect the property environmental issues. So you might decide you want to get a radon test, a mold, asbestos, any of those types of tests. And wood destroying, insect infestation, inspection report. If you want to get like a termite report, it's your responsibility and at the buyer's expense. Shall be made by a Tennessee licensed and chartered pest control operator. Request for treatment or for repair, if any, should be addressed in the buyer's request for repairs. So after we've done the inspections, we submit a repair request. Okay, buyer's inspection and resolution. So 10 days might be the norm. 7 to 10 days is the norm. I know that if we put down 14, I've had a lot of sellers push back and say they don't want to take it off the, because technically it's off the market during this inspection time and you're making a decision. I have access to many inspectors and can usually get someone out there. I normally can do it in 7 days. A few times I've had to do 10 days. because some of the, depending on the binding date, you've got weekends in there. So this is something we'll discuss and talk about before we submit it, so that we can have the best option of getting an accepted offer. But basically, this is, we get someone out there and to check out the property within, I usually do 7, sometimes we do 10. Like I said, depends on who, if you have a particular person you want to go out there, you need to check their schedule and see if they're going to be available. A lot of times I will, if it's, if we're competing against several people, it's a very popular house. That still happens sometimes, where they're like getting multiple offers, or we want to get in there. I will suggest we do 7, and I will check beforehand and see if I can get an inspector out there before I promise that. In the event buyer fails to make timely such inspections and respond within said time frame as described herein, the buyer shall have forfeited any rights provided under this section 8, and in such case shall accept the property in its current condition, normal wear and tear accepted. So this is very important that we stick within this time or request longer. In said notice, buyer shall either, in consideration of buyer having conducted the good faith inspections as provided, the sufficiency of such consideration being hereby acknowledged, buyer shall furnish seller with a list of written specified objections. So we've inspected it, we found some problems. We need to be specific about what the problems are. We can accept it as is. We can furnish the seller a written list of items which buyer requires to be repaired or replaced. Okay, so let's go back. The first one has to do with, we found so many things. These are some of the things we just don't want to move forward. Second is, we'll take it as is. Third is, here's a list of things that we would like to have repaired. So now we need, seller shall have the right to request a supporting documentation that substantiates any items listed. So we've gone through the inspection report. There's something wrong with the roof, and we're going to ask them to get that repaired. Seller and buyer shall have usually 5 days, 5 to 7. So I might do another 7 days following the receipt of the above stated written list. So let's make this specific. I just got say I did 7 days to get the inspection. It's the 7th day. I now have my list. So or even if I have it on the 8th day, but the days start counting. I've had 7 days to get the inspection. We're on day 7. My inspector just got out there. He gives me a list. I now have 7 more days, 5 more days. Let's keep it similar. I have 7 more days to get this list to my seller, so that we can come to an agreement as to whether they are going to fix these things, or if they're just going to say, no, we won't fix anything, and we're going to terminate. So this is kind of a period of time when we're working on whether or not you're going to move forward. You can also waive the option to request items to be repaired or replaced. Again, this would only be if you're just going to, if you're going to inspect it, you can still inspect it. You're not, if they're saying that they're not going to, it's an as-is sale. Buyer waives the option to request items to be repaired or replaced above, and there shall be no resolution period. Buyer retains the right to perform the inspection in a timely, furnish seller with a list of written specified objections, and immediately terminate. So this is, you're going to do an inspection and you want the option to terminate. Or you can waive, I don't suggest this, waiver of all inspections. That happened a lot when we were just after COVID and everybody was crazily making multiple offers, but this is not a good idea. Okay. Completion of repairs. I know this is taking a long time, but it's important that we read this. Completion of repairs. In the event A completion of repairs deadline is not established in the repair replacement amendment or written equivalent. The buyer shall use the final inspection to determine if all the repairs. I always say I want everything done like 2 days beforehand. In the event repairs have not been completed by the established deadline, sellers shall be considered in default of this agreement, and buyers may terminate via the notification form. Upon termination, earnest money, trust money shall be returned to buyer. So we go to our final inspection 2 days before, nothing's been done. You can walk away from this house and get your earnest money back. Final inspection 2 days before, and this is where, unless buyer and or buyer's inspector's representative shall have the right to conduct the final inspection of property on the closing date or within 2 days prior to the closing date, only to confirm the property in the same better condition as it was on the binding agreement day, normal wear and tear accepted. Property shall remain in such condition until closing at seller's expense. Closing of this sale constitutes acceptance of property in its condition as of the time of closing, unless otherwise mutually agreed upon in writing. Buyer's additional due diligence options. If any of the matters below are concern to buyer, buyer shall address the concern by specific contingency in the special stipulation section of this agreement. Survey and flood certification, insurability, water supply, waste disposal. So if there's a septic tank and you want it emptied and inspected, we'll put that in there too. Many different issues can affect the insurability and rates of insurance for a property. These include factors such as changes in the flood zone, changes to earthquake zone maps, the insurability of the buyer, and previous claims made on the property. It is the right and responsibility of buyer to determine the insurability, coverage, and cost of insuring the property. It is also the responsibility of buyer to determine whether any exclusion shall apply to the insurability of said property. So earlier in this document, you had 14 days to get the hazard insurance. So this is all something that we shall take care of, because we want to make sure this is due diligence. These are options you get. The water supply, the system may or may not meet state and local requirements. It is the right and responsibility of buyer to determine the compliance of the system with state and local requirements. For additional information on this subject, request the water supply and waste disposal notification form. So I'd get that for you. The system waste disposal, the system may or may not meet state and local requirement. It is the right and responsibility of the buyer to determine the compliance of the system with state and local requirements. In addition, buyer may, for a fee, obtain a septic system inspection letter from the Tennessee Department of Environment and Conservative Division of Groundwater Protection. Again, additional information, water supply and waste disposal notification forms. There's a lot of places in the county areas that have septics, and maybe they're old, and this is something that we would have to take care of during the inspection period, and this is really important. At closing, the general warranty deed shall be subject to the subdivision and or condominium declaration covenants, restrictions, and easements of record, which may impose obligations and may limit the use of the property by buyer. Disclaimer. So it is understood and agreed that the real estate firms and real estate licensees representing or assisting seller and or buyer and their brokers, collectively referred to as brokers, are not parties to this agreement and do not have or assume liability for the performance or non-performance of seller or buyer. Buyer and seller agree that brokers shall not be responsible for any of the following, including but not limited to those matters which could have been revealed through a survey, flood certification, title search, or inspection of the property, the insurability of the property, or cost to insure the property for the condition of the property, any portion thereof, or any item therein, for any geological issues present on the property, for any issues arising out of the failure to physically inspect property prior to entering into this agreement and or closing, for the necessity of cost or any repairs of the property, for hazardous or toxic materials, for the tax or legal consequences of this transaction, for the availability, capability, and or cost of utilities, sewer, septic, or community amenities, for any proposed or pending condemnation actions involving property, for applicable boundaries of school districts or other school information, for the appraised or future value of the property, for square footage or acreage of the property, for any condition existing off the property which may affect the property, for the terms, conditions, and or availability of financing, and or for the uses and zoning of the property, whether permitted or proposed. Buyer and seller acknowledge that brokers are not experts with respect to the above matters, and that they have not relied upon any advice, representations, or statements of brokers, including their firms and affiliated licensees, and waive and shall not assert any claims against brokers, including their firms and affiliated licensees involving the same. Buyer and seller understand that it has been strongly recommended that if any of these or other matters concerning the property are of concern to them, and they secure the services of appropriately credentialed experts and professionals of buyers or sellers' choice for the independent expert advice and counsel relative thereto, buyer and seller acknowledge that photographs, marketing materials, and digital media used in the marketing of the property may continue to remain in publication after closing. Buyer and seller agree that brokers shall not be liable for any uses of photographs, marketing materials, or digital media, which the broker is not in control. Brokerage. As specified by separate agreement, the parties agree and acknowledge that the brokers involved in this transaction may receive compensation for their services. The compensation may come from more than one party. All parties to this agreement agree and acknowledge that any real estate firm involved in this transaction shall be deemed a third-party beneficiary only for the purposes of enforcing their compensation rights, and as such shall have the right to maintain an action on this agreement for any and all compensation due and any reasonable attorney fees, court costs. Broker compensation is not set by law, and compensation rates are fully negotiable. Again, default. Should buyer default hereunder, the earnest money, trust money shall be forfeited as damages to seller and shall be applied as a credit against seller's damages. This is really important. Seller may elect to sue in contract or tort for additional damages or specific performance of the agreement or both. Should seller default, buyer's earnest money, trust money, shall be refunded to buyer. In addition, buyer may elect to sue in contract or tort for damages or specific performance of this agreement or both. In the event that any party hereto shall file suit for breach of enforcement of this agreement, including suits filed after closing which are based on or related to this agreement, the prevailing party shall be entitled to recover all costs of such enforcement, including reasonable attorney fees. In the event that any party exercises its right to terminate due to the default of the other pursuant to the terms of this agreement, the terminating party retains the right to pursue any and all legal rights and remedies against the defaulting party following termination. The parties hereto agree that all remedies are fair and equitable, and neither party shall assert the lack of mutuality of remedies, rights, and or obligations as a defense in the event of a dispute. Okay, so home protection plan. This is not a substitute for a home inspection, but we can ask for a home protection plan. Those are usually a third party that provides, like there's all different kinds. I'm sure you've seen some commercials for them where they come out and they will you pay a yearly fee and they give you a discount for certain covered items. Binding effect, entire agreement modification, assigning and binding agreement date. And it's taking a long time reading everything, but binding effect, entire agreement modification, assigning and binding agreement. This agreement shall be for the benefit of and be binding upon the parties hereto, their heirs, successors, legal representatives, and approved assigns. This agreement constitutes the sole and entire agreement between the parties hereto, and no modification of this agreement shall be binding unless signed by all parties or approved assigns to this agreement. No representation, promise, or inducement not included in this agreement shall be binding upon any party hereto. It is hereby agreed by both buyer and seller that any real estate agent working with or representing either party shall not have the authority to bind the buyer, seller, or any approved assignee to any contractual agreement unless specifically authorized in writing within this agreement. Any approved assignee shall fulfill all the terms and conditions of this agreement. The parties hereby authorize either licensee to insert the time and date of the receipt of the notice of acceptance of the final offer. The foregoing time and date shall be referred to for convenience as the binding agreement date for purposes establishing performance deadlines. Survival clause, any provision contained herein shall, by its nature and effect, is required to be performed after closing, shall survive the closing and delivery of the deed, and shall remain binding upon the parties in the agreement, and shall be fully enforceable thereafter. This agreement is intended as a contract for the purchase and sale of real estate and shall be governed by and interpreted in accordance with the laws and in the courts in the state of Tennessee. Time is of the essence in this agreement. Got terminology. I'm not going to read. I'm going to expect you to read. You need to go over this before you sign it, now that I've talked about a lot of this. In the event of performance deadline other than the closing date as defined herein, date of possession as defined herein, completion of repair deadline as defined in the repair replacement amendment, and offer expiration date as defined in the time limit occurs on a Saturday, Sunday, or legal holiday, the performance deadline shall extend to the next following business days. This is very confusing for a lot of people. Holidays as used herein are those days deemed federal holidays as pursuant to the USC section 6103A. In calculating any time period under this agreement, the commencement shall be the day following the initial date. So like the binding agreement date is not day one, it's the next day. The responsible buyer and seller agreed to timely take actions and produce, execute, and or deliver information and documentation as is reasonably necessary to carry out the responsibilities and obligations of this agreement. So you need to cooperate. Notices, except as otherwise provided herein, all notices and demands required or permitted hereunder shall be in writing and delivered either in person, by a prepaid overnight delivery service, by facsimile, by the post office, or email. So email, and if you need, we say, did you receive? Okay, risk of loss, the risk of hazard or casualty loss or damage to property shall be borne by seller until transfer of title. If casualty loss prior to closing exceeds 10% of the purchase price, seller or buyer may elect to terminate this agreement with a refund of earnest money trust to the buyer. Property is being sold without regard to race, color, creed, sex, religion, handicap, familial status, or national origin. If any portion of this agreement is held or adjudicated to be invalid or unenforceable for any reason, each such portion or provision shall be severed from the remaining portions or provisions in this agreement. And the remaining portions or provisions shall be unaffected and remain in full force and effect in the event that the contract fails due to severed. Then the offending language shall be amended conformity of state and federal law. Okay. I'm going to ask that, you come back and read these. Seller's additional obligations. In addition to any other disclosure required by law, the seller shall, prior to entering into this agreement with a buyer, disclose in writing, including acknowledgement of receipt, the presence of any known exterior injection well or sinkhole on the property, the results of any known percolation test or soil absorption rate performed on the property that is determined or accepted by the Department of Environmental and Conservation. If the property is located in a planned unit development, that's a PUD. If the property is located in a PUD, make available to the buyer a copy of the development's restrictive covenants, homeowner bylaws, and master deed upon request. If any single-family residence located on the property has been moved from an existing foundation to another foundation where such information is known to the seller, and if a permit for a subsurface sewage disposal, that's septic system, for the property was issued during a sewer moratorium, then the buyer may have future obligation to connect to the public sewer system. So these are all documentations that you would get ahead of time. Then the method of execution, agree to signatures and initials transmitted by fax, photocopy. We usually do a transaction desk sign, or there's different electronic signatures. By digital signature, exhibits. So if we have any special exhibits to attach to this, special stipulations, this would be where a lot of times I would add the closing costs. I would put closing costs, sorry, my dog's messing with me. I would put the closing costs in here to be paid. And then I would also put, since we're negotiating with the seller, for the percentage paid to the buyer's agent. Someone's put that in here. If there's a contingency, I put that in here. And then any special stipulations that you're putting in here, we want to make sure that that's also included here. It may be stated above, but let's make sure that it's very clear. If you're asking for something that's not on the list, so we don't dispute it later, say they didn't put the refrigerator as included, we're asking for the refrigerator. So time limited offer. The offer may be withdrawn at any time before acceptance with a notice. So say you put in an offer and then they haven't countered or accepted. Anyway, you've changed your mind, you could withdraw it. But we usually ask, give them 24 hours. There's been times when people have, like I've been on the listing side, and perhaps they want to know within 2 hours. It's a little pressure. A lot of times you can't answer it. But anyway, there's a time limited offer we give them, accepted by a certain time on the certain date. Usually, like I said, I like to give people 24 hours so they can think about it. And then you sign it. We send it to them. They either accept it, reject it, or they counter and send us a counter offer. See, do I have time? And let's just real quickly, usually with a purchase and sale agreement, there's a timeline. I can give you this timeline if you're first time buyer, and kind of give you like within 3 days of the binding agreement. So this gives you dates so that we know what to do. So a lot of times, here it is. Okay, so let's go through it. Earnest money, trust money has to be deposited by a certain time. I would give you where it's supposed to go. Financial obligation, this would be your lender and what you need to do with your lender. Whether you've contingency waived. So a lot of times this is just a really good form to kind of give you dates and follow along. Blech, I'm so sorry. So that you can follow along your timeline. Okay, I'm back. So that was a lot. And I know that a lot of it was boring. If you're still here with me, thank you for sticking around. If you have any questions, feel free to email me. I can send you any other forms. I know that was a whole lot of reading, but I think it's really important if you're going to make an offer on a house that you read through the form. That's a contract. You're putting money down. There's quite the obligation for you and for the seller. So I think it's really important that you have the knowledge and know what you're getting into and know what the timeline is and what your responsibilities are and what the seller's responsibilities are. So, okay, that's it. I appreciate your time. I appreciate you hanging in there with me. If you have any questions, please contact me. The information, I'll put it in the chat and I will also have it on the recording so that you can find me. All right. Thank you very much.